Welcome to Ballantyne Law, clear, practical legal advice that works.
Buying a property in Queensland, what no one explains properly. My name's Alyssa, I'm a senior solicitor at Ballantyne Law, and I'm here with Kailani, who's a paralegal in our property team. And we're here to have a chat about some commonly asked questions when it comes to the conveyancing process in Queensland.
So first of all, when does a property contract actually become binding?
Well, in Queensland, contracts for the sale of property do have to be in writing. So it has to be in a contract and it has to be signed by both the seller and the buyer, and that's when it becomes binding. Some buyers will think that they have opportunities to change their mind afterwards. Sometimes it's the case, but it's not really a change of mind. You'll have your cooling off period unless you've waived it, and you'll also potentially have a finance condition and a building and pest condition.
So these conditions are basically the buyer's safety net?
In some ways, yes. Your finance condition means that if you're unable to get finance, you're able to terminate and receive your deposit back. In terms of building and pest, you can get a building and pest report, and if then acting reasonably, you're not satisfied with it, so there's something significant, usually something structural or of high cost to fix, then you can terminate under your building and pest condition. So there's certainly not a cover-all blanket right to terminate. It has to be under those circumstances. But yes, those are somewhat of a safety net.
And what about the cooling off period?
So the cooling off period applies to all contracts for the sale of residential property in Queensland. It's not applicable for commercial property, generally speaking, but it's 5 business days. It's a statutory right. You can be sometimes asked to waive it, so be careful that you're not signing a waiver of cooling off. But it's 5 business days calculated, including the first day that you sign. So it's not just a week from when you sign, it's including the day, 5 business days, and that you can terminate for any reason during that time. It does attract a penalty of 0.25% of the purchase price though, so that is something to be aware of.
Another thing we get asked about a lot is the deposit. You know, buyers generally hear 10% deposit and sort of panic.
Yeah.
What do buyers actually need to know about the deposit?
The deposit doesn't have to be 10%. Generally, we don't see a deposit higher than 10% just because of some provisions around installment contracts. If you only have the cash available, you can make an offer for, say, a small initial deposit of even anywhere from $1,000 to $5,000 initially when you sign the contract, and then a further deposit, say up to 5%, or just whatever you really have available as cash to offer for a balanced deposit, which you can then pay at the end of your contract becoming unconditional. So once your finance and building and pest, if those are applicable, have been satisfied, you then pay a larger deposit. It's also important to remember that the deposit doesn't go directly to the seller. It will usually sit in the real estate agent's trust account. If the real estate agent doesn't have a trust account, it'll usually be in the seller's solicitor's trust account. It'll sit there until settlement, in which case the parties will authorize the release to the seller if settlement's gone through. The agent then takes their commission out of it. It is important to aware though that if the buyer breaches for any reason, the seller is likely going to be entitled to their deposit, and certainly we recommend that you get advice should that situation arise.
So after the contract is signed, buyers often think that they just sit around and wait until settlement day, but there's actually quite a bit happening behind the scenes.
Yeah.
Did you want to explain that process a little bit more for buyers?
Yeah. So during that period, there'll be some things that you need to do. If you're getting finance, you need to be working with your broker to finalise your application so you can get that finalised, and then from there you get your loan documents so that you can actually get the funds at settlement there. You've also got to arrange a building and pest inspection if you've got one. In terms of what we're doing, we're conducting searches, reviewing the results, checking council and water records to see if there's any amounts outstanding, liaising with the lender to ensure that they're ready for settlement, preparing the settlement statement with adjustments, and then also just speaking with you about the internal documents we need, like for transfer duty, authorities, that sort of thing. It is a very structured process, and missing deadlines can cause serious problems, which is why we're here to help and remind you of things along the way.
And what is one thing that you would say buyers should do before signing the contract?
Definitely to speak with us. We want to see that contract before it's signed, take a look over it. We do offer in-depth written contract reviews for clients who want that. If you just have some specific questions, we can have a look, ensure that it reflects what you've instructed the agent to conclude. So if you've asked for a finance and building and pest, we can check that that's been included and just have a quick chat generally and make sure the contract's in the form we would expect to see. It's just essential to have eyes over it before it's signed, because a lot of errors can be fixed, but some of them can be detrimental.
If you're buying a property in Queensland and you need a contract review or conveyance, contact the property team at Ballantyne Law and we're happy to help.
For more legal insights, subscribe or visit ballantynelaw.com. We're here to help.